call that Chabrowski, Mr. Chabrowski.
Okay.
Okay.
You can come up here and
He's actually not named. He's the one that filed the third-party complaint stating he should have been the other.
Right.
So
You filed the interpleader.
Yes, right.
yeah.
Right, so you can come up.
And then I have one of the parties out in the hall. The other party is
Okay,
in the back.
thank you. And you are,
Kevin Steele with Schumacher.
okay,
And then we have someone on the phone.
and then we have someone on the, is the,
I'm gonna get him transferred right now. That's what I'm trying to do.
you can even sit up here. Hello?
Your Honor?
Yes.
Ed Stokes for Jan Litwin.
Ed Stokes, you said?
Ed Stokes appearing for Jan Litwin. Jan Litwin is also on the line as well.
Oh, okay. He's with you?
Yes, he's on the line.
All right.
Well, maybe he came off the line. Hold on 1 second.
So we conference in a conference call. Oh, Ted, not Ed. Ted.
Jan, can you hear us? Yes.
Text.
Oh, okay. I'm sorry, I'm talking about you.
Something disconnected.
Okay.
Okay. All right, so the two of you are present for plaintiff Litwin. I also have in the courtroom Mr. Kevin Steele, who's appearing for Schumacher. And I have in the courtroom Derek Chabrowski, who has been asked, who has,
This Chabrowski don't have anything to do with that claim.
Right. It's okay, Jan. We'll talk about it, Jan. John, hold on. We'll talk about it. Let the judge conduct the hearing. Okay.
who has asked to be, who has filed an interpleader asking to be added to this case as the legitimate owner of the property at stake. We're not here to make any factual determinations as to the claim itself. The idea right now is just to determine what these issues are so we can identify who the correct parties are moving forward. So first let me call the case. This is CC 2016-157251. Like I said, this is a pretrial conference. The idea in this case is to clarify the posture of this case. So this case was, the complaint in this case was filed by Mr. Litwin. You go by the name of Jan?
Yes.
Okay, so it was filed by Mr. Jan Litwin against, as RB Enterprises, correct? That's what the original claim was?
No, there was basically was a mistake because the enterprise was not existing anymore, and in this time, the basically lawyer put that.
All right, but that's how the original claim was filed, as
Right, but
well.
Basically,
Correct, Your Honor.
Okay. And
my lawyer.
has there any?
Don't know.
Okay.
Jan, let her ask the questions, okay?
Okay.
At any point, there was never anything removing RB Enterprises as the plaintiff in this case yet.
Correct, Your Honor.
Okay. And then this case was filed against Schumacher. And after the filing of the case, then Mr. Chabrowski filed a motion to intervene.
Correct.
All right, hold on. We're not even getting into that issue right now. So I have a couple of questions about this. One of the things that Mr. Litwin just said is that at the time this suit was filed, that RB Enterprises no longer existed as an LLC?
Yes, this is correct.
Your Honor, if you
Yes.
need to kind of give some background, I can.
Sure.
I can kind of wait. To
Sure.
Explain that.
Okay.
Okay, so basically what happened, and this is a very long story, but I'll keep it as brief as I can. Mr. Litwin assigned a limited power of attorney for Mr. Chabrowski to set up RP Enterprises. This is some years back. Mr. Chabrowski also became involved in the operations of RP Enterprises. Unbeknownst to Mr. Litwin, Mr. Chabrowski had assigned himself certain duties with the Corporations Commission in Arizona, and had identified himself as a member. In late 2014, Mr. Chabrowski took $40,000 from the RP Enterprises account.
15.
All right.
Late 15.
All right, it's okay.
No, it was
Well-
$42,000, Jen. Anyway, to make a long story short,
Late 15.
Mr. Litwin, please.
late 2014.
Mr. Litwin, please, let's not get bogged down on details that don't matter to this right now.
Okay. And so what happened is Mr. Litwin, on becoming aware of that, immediately called the Arizona Corporations Commission. They shut down the entity. BMO Harris and Mr. Litwin have a lawsuit that's pending right now with AAA that's actually going to be converted to the Maricopa County Superior Court against Mr. Chabrowski for that conversion of those funds. Mr. Chabrowski also attempted to do the same thing in Texas. Mr. Jan Litwin's attorney in Texas received a restraining order against him and got a judgment for over $150,000. I don't know the exact figure. But anyways, we assert that Mr. Chabrowski has fraudulently converted Mr. Litwin's assets and RP Enterprises assets. Mr. Chabrowski, I know, will assert that he's the rightful owner of RP Enterprises, so on and so forth. But it is true at this moment, and at the time the action was filed, RP Enterprises is no longer an active entity in Arizona because the Arizona Corporations Commission shut it down when Mr. Litwin gave them notice of what had happened with the BMO Harris bank account. And furthermore, I would assert that Mr. Chabrowski cannot represent an entity, even assuming that RP Enterprises exists and he is the rightful owner, which he's not. In Arizona, an individual cannot represent an LLC in either Superior Court or in Justice Court. So the whole representation of him for RP Enterprises is improper.
Okay. So okay, do you have anything you want to say, sir?
Yes,
Okay.
I would love to, because, I'm general manager with Schumacher European, and I would like to give the court just a little.
Your Honor, I don't know if he's speaking into the mic or not, but I can't really hear him.
Yes, my name is Kevin Steele. I'm general manager with Schumacher Mercedes-Benz. I've been there for 23 plus years. And just for the record, in our 23 years, we had one case brought to us, and the judge dismissed it as fraudulent and irrelevant in the first 2 or 3 minutes, which we hold the position this is exactly the same kind of case. Our company has won the BBB Ethics Award for both as a runner-up and as a finalist in how we conduct our business with respect to ethics. Mr. Litwin has filed a case whereby he's seeking to recover $3,000 plus that he spent as a result of choices that he made. He reached out to us telling us that he was having problems after he brought the car back from Europe.
Right, well, okay, can I don't mean to interrupt you, and
Yeah.
I definitely want you to have your say, but right now we're trying to determine the issue of standing, and it sounds to me like you're trying to defend the case.
Well, no, okay.
We're not in a stage yet where we're getting into the facts of the case itself. We just
Okay.
want to establish, so I just wanted to have if you had anything you wanted to add as to the issue of who had standing.
Well, I would just suggest to you that our sales representative who executed this case has a very good relationship here with Derek, and we have found Derek to be an honorable person, and both Mercedes-Benz and Schumacher hold that Mr. Litwin is conducting his business affairs in a way that is not appropriate. And we would ask that the whole thing be thrown out because he eventually turned around and exported this car back to Europe, which was in direct violation of our agreement.
All right, who did you contract with?
We contracted with
RB?
Our contract was with RB Enterprises LLC.
Okay, so did we get any documentation showing? Well, it must be in this one.
There's something here right
So the shipping notice attached to the complaint lists ship to Jan Litwin. I'm going through the rest to identify.
Well,
And the contract is Jan Litwin DBA.
so
basically,
the issue though,
name on it.
the issue as I see it, and anybody here can correct me if you feel I'm mistaken, including you, is that the contract was with RB, and so the determination,
Let her talk, Jan.
the determination that I have to make now is who is the successor in interest of RB now that RB no longer exists. That seems to be the issue for this hearing.
And I guess what I'd say, Your Honor, to that issue is the Texas court has ruled that, yes, Jan Litwin is the owner of RB Enterprises. That's still a pending issue that is going to be transferred from AAA to the Superior Court in Arizona. So I guess, and I know that I don't know what the court's standing is, but perhaps it's an issue that needs to be reserved until an order comes down from the Superior Court, which obviously we're confident that they're going to find that Mr. Chabrowski, converted this asset, took it as his own, went against the power of attorney and other issues. But those may be issues that are obviously outside the bounds of this court, but the ultimate result of that bears upon who, I guess, is, like you said, what the main issue is, who is entitled to proceed here.
And you're saying that case is litigated here in the Superior Court.
Yeah, well, just to give you a background, we've been in arbitration with BMO Harris with regards to that because BMO Harris had made representation to us that they had resolved the issue. They didn't, and they allowed Chabrowski to make the withdrawal of the $40,000 in, like my plan clarified, in late 2015. And so basically what's happening is, and I actually think it was 2014, but I'll have to check the docs again. But in any event, BMO Harris has agreed with us to assist us in moving forward against Chabrowski in Maricopa Superior Court. That transition has not taken place, but it's in the works of taking place in the near future.
Can I say something, Steph?
Now,
Yeah, go ahead.
In
Let's keep
the Exhibit A, if you check it out, this is
determination.
European delivery confirmation, the contract, and clearly say customer Wodny Jan Litwin. Then, basically on my request, 1 second, on my request, also in the Exhibit B, you clearly saying the Wodny is the owner of the car on the title. The restaurant title was Chabrowski made was after valid date, after car was already sold to different dealers.
Yeah.
So basically, this is all,
manager.
And also in the purchase order
Equal power.
say board names between RB Enterprises, so both names on the title and on the deed of sale and on the contract. So you clearly say, the car was mine.
Well,
Only used by RB. Sometimes, so basically, that.
well, at this point, I mean, the purchase of the purchase of the vehicle, the purchaser name is RB Enterprises. So there's no individual named. It is just the name.
Purchase retail contract, Dan, you see that?
The purchase retail contract has the name of RB Enterprises, and at the time,
My name all things was so long, class working at Jan Litwin. But if you check the Exhibit A, clearly says this is basically contract when I paid $65,070. If working is not Jan Litwin, this is my name, where the money comes from.
I only have the purchase. Do we have the title of the car?
And also,
Jen, let her talk. Hold on.
So, and then what I have is the paperwork for the LLC is showing that Mr. Chabrowski is the member of the LLC and that Mr. Litwin is the manager. This was incorporated.
Jen,
So-
let her finish.
So this is the
Let her finish, okay?
This is the documentation that I have in front of me right now, showing that this car was purchased by RB, that Mr. Chabrowski was the member of the LLC that purchased the car. In 2012, he was the member. I'm going to go through quickly to see if there was any changes in the membership. No, this was 2000, what day was it purchased?
May 2014. May 21st, 2014.
So there was a change of address in 2014. There was no change in membership. Change of address. And so all I have is changes of address. I don't have any change in memberships, although I see that some of the paperwork was signed by Mr. Litwin, who has been marked as the manager. So all the paperwork that I have from Mr. Litwin shows that he is the manager of the LLC, not a member, that Mr. Chabrowski is the only member.
That's correct, Your Honor. That's how the paperwork will show up.
You're a manager member.
Well, what's
And
the,
like I said, Your Honor, if we wanted to delve into the weeds with this, we submit to you the limited power of attorney and everything else, and the scope of that, and the rest of the evidence that would be submitted in the Superior Court once that transfers to AAA.
well, and I understand that, but right now, I mean, I'm just looking at the paperwork that I have. Is there a difference between, is there a difference between being a member of the LLC and the manager of the LLC?
Well, and one issue I think that needs to be recognized is the retail purchase
Teacher
agreement
saying, I don't
is
know.
RP Enterprises LLC / Mr. Litwin.
It does-
There just wasn't room. There wasn't room to put his full name. If you see, it gets cut off.
And about Exhibit A is showing my name only.
Right, I understand that. Yeah.
So you're
I
saying,
mean, that goes to the nature of
But
this
the-
whole
the-
argument.
the
It's
title-
the
the-
transfer of funds was from Mr. Litwin's account.
Okay.
And he purchased a vehicle.
This
assuming
is-
that, assuming that Mr. Chabrowski had followed the limited power of attorney correctly, and that it was his entity, and Mr. Chabrowski did not and fraudulized it, and has been asserting that it's his entity since
Well-
he converted the $42,000 from the BMO.
right, well, that, I understand that, but I'm looking now, the title of the vehicle is in the name of RB Enterprises, which
and
would apparently belong to Mr. Chabrowski and in the name of Mr. Litwin.
Correct.
So
that
it's
title
it,
was
it,
frauded, that title was you have in the file is nothing with Mr. Chabrowski on it. That duplicate title, what I took you before in the first time.
all right, Mr. Litwin.
Exhibit.
All right, Mr. Litwin, Mr. Steele.
Nothing.
Mr. Litwin, please. Mr. Steele.
Okay, there's two issues that are going on here.
Hold on, Mr.
Excuse me,
Steele
you've
is
had your
speaking.
time to talk, now it's mine. There's two issues going on here, and that's the relationship between Litwin and Derek and the ARTB LLC. The issue that I'm here to address, simply put, is the fact that Mr. Litwin, in direct contrast to the rules as outlined by Mercedes-Benz, both here and in Germany, and we have people that have been through this process dozens and dozens of times, my own staff members, he violated or paragraph 7, and I've coded this as page E2 in the terms and conditions from Mercedes-Benz USA. He purchased insurance in Europe for 3 months. He stayed 6 months. And then furthermore, instead of getting the car back to the authorized agents of Mercedes-Benz Germany to bring that car back to the States, he took the car to Poland and basically somehow operated with hiring his own agency to ship the car back to the U.S. And then it's interesting to note that somehow supposedly the original title was all wrong and it had to all be redone. So we reached out on Mr. Litwin's behalf to Mercedes-Benz USA to plead his case after receiving his $3,000 in expenses. And Mercedes-Benz came back to us, and not only did they say no, they said absolutely no way, we're not helping this gentleman.
Again, I think you were correct when you said at the beginning that there's two issues here, and one of them has to do with the relationship between Mr. Litwin and Mr. Jabrowski that has nothing to do with you.
Well, I make the point in that it was Mr. Litwin who made the decision to take the car to Poland and ship it through some unauthorized shipper in
Right.
Poland.
I understand, and from my understanding, the claim in this case has to do with expenses that Mr. Litwin incurred because of these things, and he thinks that Schumacher should pay for them. But again, I'm not here to resolve that issue today. We are just here to resolve who has the right to make these claims. If I were to dismiss this case altogether,
Which is what we would like.
which is what you want, then neither of them would, it doesn't matter, because neither of them would gain anything from it because there would be no claim. But we're not at that stage yet.
Yeah, okay.
All right, Mr. Jabrowski.
Your Honor, Mr. Litwin resolved the corporation in 2015, and according to ARS, I'm the only lien holder and the only member, and he has filed a fraudulent affidavit that all the distributions from all the vehicles that were embezzled by him has been distributed through the members of the corporation. That was never the case.
Right? No. I mean, I understand that there are mutual charges of fraud between the two of you. Mr. Litwin says that you're the one who committed acts of fraud. You're the one saying that Mr. Litwin is the one who committed the acts of fraud.
Except the only case
this is-
of Judge Reyes in federal court to which Litwin has not responded to it. And we just served him on the 14th of January.
All right, but whatever litigation.
Cases against me as of yet.
So, I'm going to have to take this under advisement. I'm going to have to look at the documentation and make a decision based on the information given. And then we'll go ahead and set a trial date in this case. If Mr. Litwin prefers, we can just dismiss this case altogether. And
Your Honor, I have one said, the Mr. Ken from the Schumacher in the present, so he can prove of my words. that program, European delivery program, is not even possible to do this in the LLC or without, because, it's not working that way. You have to be private individual who private pay for the car. And
Okay.
private ticket on that car from Germany.
This,
Basically,
I am,
through LLC.
look, I am clear that Mr. Litwin's name is on the title of the car, as well as RB Enterprises. So either RB Enterprises allows Mr. Chabrowski standing in this, or it doesn't. That is the only determination. Mr. Litwin's name is clearly on the title. If there are allegations that the title is fraudulent, that is something that is not for this court to determine. So,
That's correct.
so like I said, well, yes.
If I just may, one thing that's, and this may be my fault, I looked over the documents and I talked to the clerk of the court, and this may be helpful to you if you'll permit us some time. But when I came on the case last week, when Mr. Litwin asked me to come on this case, it was my understanding that today was a mediation, and it was a continued mediation hearing. And I called the clerk of the court, and that was verified. So I apologize that I didn't know. I mean, when I got the order in the mail yesterday, I saw that it said pretrial conference, and I talked to the clerk of the court about it earlier. I assume the pretrial conference was scheduled merely to resolve this issue of standing before we move to mediation. Is that how I understand it?
Exactly.
Okay, perfect. And with that said, I feel, I mean, almost, I guess as I use the word, I feel bad that you have this very complex issue before you, but it hasn't really been properly briefed. If the court would like to grant maybe, 2 weeks or something, we could make a 5-page brief that would explain this issue of standing and the issue of RP Enterprises' involvement in this suit and Derek Chabrowski, if it would be of assistance. If not,
No.
I mean, obviously the court can proceed how it would feel.
I mean, right now I'm inclined to allow the interpleader and then continue the case with the 2 plaintiffs. I mean, that's right now what my inclination is.
So allowing Chabrowski to stay in and allowing Jan Litwin to move forward as well.
Right.
And then ultimately at trial we would resolve the issue of standing.
Right. I mean, that's what I'm thinking right now. Because I think that Mr. Steele is really chomping at the bit to get this to trial, to get this case
For something
resolved.
like this to have to go to trial, Judge,
Sir, I understand what you're telling me. I cannot resolve a case based on the fact that you think it shouldn't have been filed in the first place. Unfortunately, that's not. You can look into filing something if you want, but that's something that you have to do. I can't do anything for you.
Okay.
All right? So why don't we get a trial date? I would say we set a trial date maybe 90 days out.
Your Honor, can I have the name of this attorney?
Yeah, so we're going to get the name.
And is he licensed to practice in Arizona?
Mr. Stokes, are you licensed to practice in Arizona?
Yes, I am.
All right, we need your phone number. We need an email address.
Okay, would you like me to say that out loud, or how would you like me to say that? I don't mind.
Okay, yeah, go ahead.
Okay, it's 801
Uh-huh.
438 4864,
Okay.
and my email address is ted@StokesLaw, P as in Paul, L as in Larry, L as in Larry, C as in Charlie.com. It's ted@StokesLaw, PLLC.com. And then if you want my bar number.
Yes, your bar number, please. What is it?
030575. 030575.
Okay. All right.
First, can I have the word also? What about that situation that Mr. Sabro can represent,
Yes.
myself? You have to hire.
There is an issue that the court didn't take on is if Chabrowski is asserting that he is in the case on behalf of RP Enterprises, he can't represent RP Enterprises himself. He has to have counsel.
Well, he's not. how can he be representing the enterprise if the enterprise has been dissolved? He is representing his interest in the liquidation of the enterprise.
Right, and so my question is does he assert to represent Derek Chabrowski or RE Enterprises? Because that's not clear through the pleadings I've seen.
Well, you yourself tell me that the enterprise no longer exists.
I understand that.
And so he's asserting his rights not as, from what I understood in his, I mean, he can speak for himself, I guess. From what I understood from his pleading was that he is asserting his rights as as the lien holder of the property of the liquidated LLC. Well, that's something that we will have to determine.
No, you got the title in front of you. You know, my title, original title was the issue. You know, no legal.
Jen, we're just trying to determine. I'm just trying to determine Mr. Chabrowski's standing in this case. Is it going on behalf of himself or going on behalf of our enterprise?
Are you appearing on behalf of yourself?
Myself.
Okay, on behalf of himself.
Okay.
Judge, if
Okay,
I could
I
add
will.
one
There
last
might be some, because of the way the dates of the filings occurred here. Mr. Chabrowski did file something that you did not get because we did not have an appearance, your appearance on the record, Mr. Stokes.
Right.
So we'll be sure that you get a copy of all that information, and then you'll be able to see what he has filed.
Judge, one,
Thank you so much.
Because he lays out a declaration with all of what he considers his standing is.
Okay.
All right?
Judge, one
Okay, one more
last
thing,
point.
Mr. Steele. And-
Yes, we have tried to take care of this situation to our very best, and I just want to make sure that Mr. Litwin's counsel is aware that we had an offer letter, basically which said, look, this we didn't do this. This is something that he did. However, thus far we have not hired attorneys and everything. But if I have to go and hire an attorney to take this to court, we are going to countersue him for the $10,000 that we are entitled to every penny of, and clearly
Don't have his attorney call me if he wants to.
he
All right.
he signed a document acknowledging our rights to that. So
Okay.
I would just once again encourage us all to maybe the smartest thing to do is just all walk away from this.
All right, well,
I'm happy to discuss settlement offers, but you have to call me and talk to me.
okay, so you can call Mr. Stokes. Did you write down his phone number? You have it there?
I did not.
Okay. I'm going to set the trial for April 11th at 9 a.m. Can they get the home April 11th?
You said like 2 months out.
Yeah, but what is that? That's a Tuesday morning, so all morning, right? Can you block the rest of the morning for the trial?
If you think it's gonna be that long.
Yes. All right, we're going to block the whole morning. April 11th at 9 a.m. will be the trial in this case.
Your Honor, I understand the court has
Do-
calendar and accommodation. Might it be able to accommodate? I looked about 90 days out. I have hearings basically through mid-April scheduled on Tuesday, Wednesdays, and Thursdays. If I saw the 11th right.
Well, we have to do a Wednesday. We can do it more towards the end of April.
Well, I was thinking, if possible, if this could get pushed into May. If the court doesn't want to go out that far, I understand.
About May 2nd.
May 10th would be is open for me right now.
That'd be a
Like I said, I do have hearings scheduled through May 9th, or through April 19th thus
Has to
far.
be a Tuesday or Thursday.
Oh, it has to be a Tuesday. It has to be a Tuesday or a Thursday. So May,
Oh, Tuesday or Thursday?
yeah, so either May 9 or May 11.
I would say the 11th would be best for me,
All right.
but I also don't want to.
No, that's fine. May 11th at 9 a.m. And do we need to set disclosure deadlines?
Your Honor, where we're this close, I I would assert that parties should agree to have everything disclosed by 30 days prior, so roughly April 11th or whenever that
Okay.
day is.
All right, so disclosure will be due by April 11th. All right, and you'll let us, I mean, if there's any discovery issues, you'll let us know, but if not, we'll see everyone here on May 11th.
Your Honor, might we be permitted within 7 days of the trial to submit just a brief, not an extended brief, but a small brief of our positions going into trial?
Can you repeat that?
I asked if the court would permit a trial brief to be filed maybe perhaps 7 days prior to the trial, just so the court can understand our position a little more clear going into trial.
All right, that's fine. All parties may do that.
Okay. Thank you, Your Honor.
All right, anything else? All right, we will see everyone back here on May 11th. Thank you. I wrote it down somewhere.
You can give it to the parties so they have it as well.
Oh, she took it probably, right? She hasn't.